A seller recently came to me claiming that his father had left his property to him in a trust, but the buyer's title company was claiming that he had to go through the court probate process to be able to sell it. This didn't make sense to him because he thought the whole point of the trust was to avoid probate. As we reviewed everything together, it was clear that his father had in fact created a revocable living trust and stated his intention within that trust that his property pass under the terms of the trust to his son. But he missed the crucial second step of funding the trust, and probate was required. The good news for my client is that we were able to get the probate process started immediately, and he was able to sell the property by the contractual closing date. But today's tip will explain how you can avoid this common mistake entirely and what it means to fund the trust. Stay tuned to the end for a Realtor Pro tip that will help you catch this issue as early as possible. A trust agreement that says who gets the property is just an expensive piece of paper unless the asset is also titled in the name of the trust. This is called funding the trust. A bank account statement or stock certificate can be updated to show the name of the trust, and with real estate, the deed should be updated to show the owner not as you individually, but you as trustee of your trust, the date the trust agreement was signed, and the powers you or the successor trustees after your passing have to sell the property. And now for the Realtor Pro tip. If you're preparing to take a new listing and the owner has mentioned that they put the property in their trust, verify this by visiting the property appraiser's website, pulling up the property's profile, and scrolling down to the clickable link that allows you to download a copy of the most recent deed. You'll want to see who the deed shows as the grantee. If it simply names an individual, then the property is not in trust, and you'll need to inquire further with your sellers. If the trustee of the trust is named as the grantee on the deed, then your seller funded the trust, but there's still one more thing to look for. There should also be language that describes the powers that the trustee has, such as to sell or lease the property. If that language is missing, that's okay, but the seller should be prepared to produce a copy of the trust to the title company that's handling the closing, because they'll have to record pages of that trust that show the trustee's powers in the property records alongside the deed to the new buyer. If you've inherited property and it's too late to plan around these mistakes, our office can help you navigate the probate process efficiently so you can stay as close to that initial closing timeline as possible. Text the word probate to 561-225-2676 to set up a time to speak with me.